Welcome to episode 12 of Fixing America with J. Mel. This episode is entitled How the Rule of Law and Constitutional Limits Are Designed to Protect and Preserve Popular Sovereignty. In the last episode on popular sovereignty, we discussed two things that determine when the people in a sovereign nation hold power: free and fair elections, and leader accountability. In this episode, we continue that discussion with the third factor that determines when people in a sovereignty hold power. And that factor is, number 3, rule of law and constitutional limits. The Constitution and rule of law are the containers within which the people's power is held and dispensed. The Constitution is the outer container. It defines the people's sovereignty. It is the highest expression of the people's will. The Constitution declares that sovereignty belongs to the people, establishes institutions, like the branches of government, sets officers, terms, and qualifications, defines scopes of duties and authorities, sets rules for elections, lawmaking, and leadership changes, and outlines rights and limits that even the government cannot violate. If done properly, the Constitution defines the values and systems that will sustain and prolong the life of democracy, and it includes the values that will promote internal and external peace. The rule of law means that all citizens are bound by and accountable under it, including leaders, and even the ones enforcing the laws. It requires that no one governs outside its constitutional authority, and that all power must be exercised only according to law. The courts are authorized to strike down any illegal acts and any laws that violate the Constitution. It is the primary way citizens' rights are protected so that their voices may remain effective. Without the rule of law, the Constitution would be meaningless, and leaders could ignore it. Then the people's sovereignty would vanish. Trump has flaunted his disdain for the Constitution and rule of law hundreds of times during the first year of his second term of office. One of the most flagrant was Trump's infamous Executive Order number 14160, which denied citizenship based on birth of a child born in the United States to undocumented immigrant parents in direct contravention of the 14th Amendment to the United States Constitution and 8 United States Code, Section 1401. A district court entered a universal preliminary injunction barring execution of the president's order to anyone in the country. The matter was appealed to the United States Supreme Court, which granted the government's application for a partial stay on the basis that the district court lacked authority to bind any jurisdictions other than its own. In other words, it held that the district court's universal order was too broad and therefore could not be enforced outside its own jurisdictional boundaries. The Supreme Court did not rule on the merits of the constitutionality of the president's executive order. The reason that is so egregious on Trump's part is that he was attempting to change the United States Constitution by his arbitrary decree or fiat, like a king, dictator, or tyrant would do. He does not have the authority to change statutory laws passed by Congress. But birthright citizenship is not an ordinary law. It is an amendment to the Constitution. As stated above, it is part of the organic system of our government. It is what breathes life into the people's power. If that can be done by one person simply because he is elected president, we have lost our power as a people and conceded it to him. Whether you believe that a person born of non-U.S. citizens should automatically be a citizen of this country is one thing. But who makes that decision is quite another. And I haven't met anyone yet who agreed to vest Donald J. Trump with that authority as a candidate for president. And I do not believe anyone would grant him that authority. If you did, you would be dissolving your democracy. Another flagrant abuse of the rule of law and constitutional limits by Trump has been his sweeping anti-DEI and related funding directives. Before we proceed into this subject, we need to understand what government DEI programs were designed to accomplish. The stated purpose of government diversity, equity, and inclusion, that is DEI, programs was to create a fair and inclusive environment for recruiting and promoting people from diverse backgrounds. Diversity is not an accident in a liberal democracy. It is a necessary condition for its freedom and vitality. It is both a moral commitment to equal human dignity and a structural safeguard against tyranny or stagnation. Because the Obama and Biden administrations have been more progressive, they have advocated for more diversity. The right-wing conservatives have responded aggressively to repel that trend with calls for cultural homogeneity. Homogeneity is the quality or state of being all the same or alike. It produces pleas of cultural displacement like, "This isn't the country I grew up in," or loss of identity like, "Our traditions are being diluted," or loss of control like, "Outsiders are changing the rules." One that I hear a lot and have even said is, "Well, at least she speaks English." But I do not say that anymore, and I regret having ever said it. Problem is, diversity in our society has caused uneasiness and even fear. People prefer sameness to feel safe. They gravitate to what is familiar, normal, and socially predictable. They translate their preference for sameness into political forms such as nationalism, like, "We need one dominant national identity," or one religious tradition. "Our moral order depends on one faith or moral code." Or they conclude that authoritarian populism is the answer. Diversity causes division. Unity requires one culture. The paradox is that societies that enforce homogeneity often become less stable. By contrast, societies that tolerate diversity but hold firm on equal rights, rule of law, and civic responsibility tend to be more stable and innovative. In a liberal democracy, diversity is what allows unity to exist without coercion. It is the antidote to enforced sameness. Diversity was rooted in the Civil Rights Act of 1964 and the concept of affirmative action. It has historically been presented as a way to address systemic barriers and ensure all Americans have equal opportunities. The Civil Rights Act of 1964 was legislation designed to end segregation and discrimination based on race, color, religion, sex, or national origin, particularly in public accommodations, public education, and federally assisted programs. Most of the Trump DEI executive orders have been temporarily blocked by federal courts while ongoing lawsuits are litigated, including lawsuits contesting the constitutionality of Executive Orders number 14151, 14168, and 14173. A common basis for the courts to block them is that they are unconstitutionally vague and ambiguous and violate constitutional due process. I mention that because I've always had a tough time getting my head around the concept of an anti-DEI program as being bad, wrong, or evil. To me, discrimination is bad. DEI is, by definition, against discrimination or anti-discrimination. So when Trump says he is anti-DEI, he is declaring that he is against being anti-discrimination. In other words, Trump wants to be able to discriminate with impunity. So, when I learned that Trump administration DEI executive orders are found by the courts to be vague and ambiguous, to me it means that the administration really does not want to come out and say what they really want to do, which is to return to the days of Jim Crow. The same is true with the woke concept, which even the MAGA crowd has trouble defining with any precision. That is because they are embarrassed or politically afraid to come out and say what they are trying to do. Return to the Jim Crow era when discrimination was acceptable conduct. When talking about DEI, we are talking about protecting people or groups of people from discrimination based on race, religion, minorities, and sex. In the United States, we have an interesting cycle of how those groups of people have been treated. For 242 years, from 1619, when the first African slaves were brought to the colonies, to April the 12th, 1861, when Confederate troops fired on the Union forces at Fort Sumter, South Carolina, black people, Native Americans, women, and minorities were subjected to severe oppression, discrimination, and violence. 4 years later, after suffering some 698,000 deaths, the Civil War ended on April the 9th, 1865, when General Robert E. Lee surrendered to General Ulysses S. Grant at the Appomattox Courthouse in Virginia. That year, Congress passed the 13th Amendment to the U.S. Constitution, abolishing slavery. 3 years after that, in 1868, Congress passed the 14th Amendment, granting birthright citizenship to all persons born in the United States. 2 years after that, in 1870, Congress passed the 15th Amendment to the Constitution, granting the freed American slaves the right to vote. From the end of the Civil War in 1865 to the time of the inauguration of Rutherford B. Hayes as president on March 3, 1877, federal troops had been stationed in the South to protect the freedom granted to the black slaves. His election was contested and in turmoil. To end that fuss, the political powers of the day entered into what came to be known as the Compromise of 1877, which paved the way for his inauguration and the withdrawal of federal troops in the South who had been protecting the freedom of the blacks. That act of removal of federal troops effectively authorized the rebirth of the Old South and its discrimination against minorities and black people in particular, and sanctioned the introduction of the Jim Crow era. So, after 242 years of oppression, 4 years of bloody war, and roughly 12 years of, quote, reconstruction, this group of minorities were cast back into a situation almost as bad as the one they had endured for 242 years. And in the case of everyone except the Negroes, there was no improvement even during the period of Reconstruction. For the Negroes, they did have the benefit of the passage of the 13th and 15th Amendments to the U.S. Constitution, which abolished slavery in 1865 and granted them the right to vote in 1870, respectively. But the Jim Crow era would make both of those advancements seem like hollow victories because the states effectively systematically stole the rights away by other oppressive and suppressive means that were remarkably effective. The Jim Crow era in American history was a period from roughly 1877 to the mid-1960s characterized by state and local laws that enforced racial segregation and discrimination against African Americans. It was lawful not to treat black people with dignity. They were forced into segregated schools, inadequately funded, denied access to higher education and skills training, relegated to hard labor, discriminated against in housing, securing loans, denied equal access to build equity, eat in restaurants, recreate, swim, associate, or compete with white folks, or even live in the same neighborhoods with adequate public utilities and police protection as white folks. Women did not make much progress very quickly either. They were not granted the right to vote until 1920 with the passage of the 19th Amendment to the United States Constitution. In Texas, they had to wait until the passage of the Marital Property Rights Act in 1967 to gain the right to own property, secure loans, and manage businesses independently without their husband's signature. Equal pay has yet to be achieved for women, and as we have discussed elsewhere, they have only very recently been granted access to positions as lawyers, engineers, judges, clergy, professors, scientists, medical doctors, and other positions of respect and higher learning. The Civil Rights Act of 1964 prohibits discrimination based on race, color, religion, sex, or national origin. Its purpose was to end segregation in public places, ensure equal access to public accommodations and education, and prohibit discrimination in employment. The act is largely still in effect today. In 2020, the Supreme Court ruled that the Title VII prohibition on discrimination because of sex includes sexual orientation and gender identity in Bostock versus Clayton County. The Supreme Court, while upholding the principle of affirmative action, has limited its scope by striking down racial quotas. The Voting Rights Act of 1965 prohibits racial discrimination in voting. It was amended in 1970 to eliminate literacy tests, again in 1975 to expand protections for certain language minorities, again in 1982 to ban voting practices that have discriminating effect even if discriminatory intent could not be proven, and again in 2006 pertaining to reauthorization of Section 5's pre-clearance requirement. The pre-clearance requirements of Section 5 were largely abolished by the U.S. Supreme Court in Shelby County versus Holder in 2013. That site is 570 United States 529. Our discussion of when the people in a sovereign government hold power has covered free and fair elections and leader accountability. And now a brief discussion of the rule of law and constitutional limit, but we are not finished. Trump has robbed our popular sovereignty by violating the rule of law and our Constitution's limits in other ways. Join that discussion in the next exciting episode. Thanks for listening. Remember to like, comment, and subscribe. I hope you join me for the next exciting episode of Fixing America with J. Mel.